right, good morning. Happy New Year, everyone. I'd like to call this meeting order. My name is Carrie Ann Farrell Hines. I'm the chair of the California Board of Accountancy Committee on Professional Conduct, and I'd like to call our meeting to order. Let's start by taking roll. If I could start with my colleague at the end of the table over at this end.
Okay.
Jose Campos.
Carrie Ann Farrell Hines.
Michael Savoy.
Mark Silverman.
Nancy Corrigan.
And with that, we have a quorum. Let's move on to our first agenda item, which is the approval of the minutes of the November 21st, 2019 Committee on Professional Conduct. May I have a motion to adopt the minutes?
I move to approve.
Second.
Are there any additional comments or discussion from committee members? Are there any comments from the public? I'll now call for the vote. Ms. Reed, please call the roll.
Jose Campos,
Yes.
Nancy Corrigan,
Abstain.
Carrie Ann Farrell Hines,
Abstain.
Ariel Pay,
Yes.
Michael Savoy,
Yes.
and Mark Silverman.
Yes.
Motion carries. Thank you very much. Moving on to agenda item number 2 is a discussion and possible action regarding CPA firm mobility. Mr. Franzella, please begin your presentation.
Thank you and good morning. So for this item, the CBA is being asked to decide whether to take steps to further explore CPA firm mobility, including possibly any, what it would take to do it via statute or regulatory changes. So for the benefit of some of the newer members who were not on the board during the CPA's development of its mobility report that we submitted to the legislature back in December of 17, in that background section, I provided a fairly detailed overview of the evolution of mobility in California. But for the purposes of my remarks today, I'll focus on the comment section of the agenda item, which is on pages 3 and 4 of your materials. So since July 1 of 2013, individual CPAs may practice in California without providing notice or pay a fee, provided that they do not maintain a principal place of business in California and meet one of the 3 conditions that we've outlined at the top of page 3. Similarly, CPA firms have expansive mobility under the California mobility provisions. Most CPA firms who do not have an office location in California can practice through an individual authorized to practice under mobility without providing a notice or paying a fee. The only time a CPA firm is required to be registered with the CBA is when the firm, again working through the licensee that meets the mobility requirements, provides specified services to California headquartered entities. The list is noted at the top of page 4 and include audits, reviews, prospective financial information, and certain compiled financial statements. CPA firms providing these services must submit a registration form, which is included in attachment 1 to your item, but there is no associated fee. These firms that obtain the registration must renew it every 2 years, and the firm would automatically cancel after 5 years of non-renewal. For national purposes, the UAA provides for what's called complete CPA firm mobility, and attachment 2 to your item is section 7 of the UAA. And attachment 3 is a map prepared by NASBA that notes that 29 states have adopted CPA firm mobility and 1 state has pending legislation. Presently, the CBA has just shy of 700 out-of-state CPA firms that have been issued a registration by the CBA. With the exception of this narrow requirement, in California, in essence, CPA firms have basically CPA firm mobility. So should the board seek to institute full CPA firm mobility, staff will work with Department of Consumer Affairs, assign legal counsel, develop any requisite statutory changes and potential regulatory changes, and present them at a future meeting. At this point, I'll turn it back over to discussion to the chair, and I'll be happy to try to do my best to answer any questions members may have.
All right,
So do we have discussion or a motion on this item? Are there any questions or comments from the committee members? So there's not a motion here that needs to be made to adopt, and there's no other discussion from the committee members, or?
No, this topic has been kind of on the radar of the board and staff for a little while, but there was an appetite to get through the CPA individual mobility process. And as it's been in kind of the parking lot for a while, we put it forth to gauge the board's appetite to continue to discuss this matter. If the board is not inclined to do anything at this time, no action is necessary, and we'll just continue to monitor it on a national level and as the board wants.
Okay. Are there any comments from the public on this item?
Morning, Jason Fox, the California Society of CPAs, and I just wanted, for the record, I think we would like to see full mobility and firm mobility at some point, but recognize that California's program is a little bit unique, and there's a lot of things we kind of work through. So certainly not something, in the immediate near future, but I think we'd like to move in that direction at some point with working with the board and the legislature. So certainly it's some complications that we need to work through. We want to do it right when we do it.
So, Dominic, if I understood the summary, we basically have firm mobility with the exception of primarily a test-related individuals who are seeking to perform a test services in California.
Yes, but even more narrow in terms of it being a California headquartered entity, not just, if they can enter California and do audit work or test functions, that might be for,
A subsidiary,
Yeah.
a division.
but it's only if it's issued, and California headquartered entity really is driven by the client as they designate whatever that is. And then if they issue that report to a California located business, it's in that, it gets even more narrow as you kind of look at it that way.
And the history of this was with individual mobility, that aspect of communication or notification was highly important to the process of getting individual mobility passed in the state, right?
Yep.
And so I know that was some aspect of what the Mobility Stakeholder Group Committee monitors, and there were various things we had to do on an ongoing basis to accomplish that. So it seems like a difficult one to, navigate, given, I think, the history of individual mobility at this point.
One other point I'd like to raise, of the 700 or so that we've issued, there's been a lot of dialogue when we've had questions with them. I wouldn't even say 700 have actually exercised that particular registration. They've been more proactive in the sense of, if something comes up with it, I want to be able to perform that work without having to kind of go through any registration at a later date if a client approaches me in that particular way. So I wouldn't even say of the 700, that many are actually performing those services. They're kind of just getting out in front of it as well. Again, I don't have any empirical data, but it's more anecdotal in terms of what we've heard and discussed with some of these individuals.
Are there any other comments? All right, well, hearing none, then we're going to go ahead and move on to agenda item number 3. And Mr. Franzella, you have the floor again.
Thank you. So agenda item 3 is a discussion and possible action regarding accounting firms providing attest services with ownership comprised solely of CPAs who have not completed the attest experience requirement. The CBA is being asked to consider directing staff to explore possible statutory, regulatory changes, or both, related to licensees who have not completed the attest experience requirement, who are sole owners of accounting firms that provide attest services. Last year, staff presented information to EPOC related to CPAs who have not completed the attest experience requirement but were performing attest work. And as part of that paper, staff included information in the item related to this particular topic on owners of accounting firms who are basically G licensees, the non-attest experience licensees performing attest services through their firm. The CBA, at the recommendation of EPOC, directed the CPC to further explore this topic. The CBA, for background purposes, the CBA does not issue licenses noting authority to sign attest reports on attest engagements to accounting firms like it does for its CPAs. I've highlighted on page 2 of the materials the attest experience requirement individuals must complete in order to obtain a license that authorizes them to sign reports on attest engagements. As the CBA does not issue licenses to firms in this way, based on general or attest experience, there's no prohibition against these accounting firms performing this work. Further, in the materials on page 3, I've included CBA regulation section 50.1, which relates to client notification in these types of situations, that basically contemplates that the board is allowable to these types of situations under client notification requirements. With no owners in a position to sign reports on behalf of the accounting firm, presumably either they have a CPA on staff who has been issued a license with the attest experience, or they contract with CPAs. Staff have noted at least 4 areas the CBA may wish to consider seeking some type of either statute or regulatory change, or potentially both, to ensure consumer protection. 1 is enhanced client notification, 2 is peer review notification, 3 is professional responsibility for enforcement action, and 4 is work paper retention requirements. In this item, I've included each of these 4 areas in subsections, with the first area, enhanced client notification, near the bottom of page 3, and I'll just kind of step through each one. Again, while the CBA regulation section 50.1 does require certain notification to clients and prospective clients, and again, retention of that notification, the CBA could consider requiring accounting firms to include in the engagement letter for their attest services a notification of the client of the name and the license number of the CPA that the accounting firm has authorized to sign the attest report. 2 potential consumer benefits to requiring such a notification in the engagement letter are the client will have the ability to perform a search of the CBA website to ensure the licensee has completed the necessary experience, and the client will be able to determine if there are any enforcement actions pending against, or enforcement actions taken against that licensee. Moving on to the second area, peer review notification. Accounting firms who perform accounting and auditing services must complete peer review once every 3 years. As part of the peer review, the peer reviewer selects a cross-section of work performed by the accounting firm, including work performed by all signers or responsible parties of reports. With the owners not authorized to sign, the CPAs who perform the work may no longer be with the accounting firm, or an outside CPA may have performed that work on behalf of the firm. The CBA could consider requiring the accounting firm to disclose to their peer reviewers that no owner is authorized to sign reports on attest engagements. As for the area of professional responsibility for enforcement actions, this is the third area, and it can be found on page 4 of your materials. Audit engagements require accounting firms to have written quality control policies and procedures, and we've kind of posed a couple of questions. What step, if any, must ownership take to ensure proper adherence to the policies and procedures, including reviewing work or hiring a licensee to review work when ownership doesn't possess the requisite attest experience? Additionally, the owners are not individually responsible for the engagement, as they are not signing the report. The CPA who is authorized to sign reports on the attest engagement performs negligent acts during the course of the engagement. Should the owner also bear the responsibility for those negligent acts? So the CBA may wish to make any necessary changes to have ownership take on the same responsibilities as if they were licensee who performed the engagement. This would ensure that the negligent acts performed by the accounting firm, which the owner, again, is ultimately responsible for, are extended to the owners who choose to take on these types of services. And the last area is work paper retention, and it's on page 5 of your materials. In this particular scenario, the accounting firm is the owner of the work papers. Staff or the contract employees who were the responsible parties to the engagement may have left the accounting firm and are likely no longer have access to these working papers. If the CBA opens an investigation, it is crucial that the signer have access to the work papers to answer questions as part of our investigatory process. So the CBA could consider requiring accounting firms to make these documents and these work papers available to the licensee for purposes of conducting an investigation and being able to answer questions during the course of our investigation. So I believe it's the page 5. Yeah, page 5, we've highlighted some next steps related to this topic. So should the CBA decide to recommend modifications to any of the issues that we've noted, Staff will work with legal counsel to identify the necessary modifications that may need to occur both in statute, regulation, there could be a combination thereof, and we'll bring them back as directed by the board at a future meeting. As the CBA considers any changes, staff wanted to highlight two other attest-related topics that will likely be coming up before the board. These can be found on pages 5 and 6 of your item, and they include changes to the UAA related to accounting firms maintaining a test experience requirement, and possible CBA discussion on how owners of accounting firms who have not completed the attest experience requirement can take steps to complete this requirement. On page 6 of your item, staff have highlighted or provided recommendations for the various areas. And at this point, I would like to turn discussion back over to the CPC, and I'll do my best to answer any questions members may have.
Thank you, Mr. Franzella. So these are 4 pretty significant items, so we're going to just take them one by one to have a discussion and potentially act. Why don't we start with the enhanced client notification? So staff have recommended that accounting firms be required to include in their engagement letters for attest services a notification to the client of the name and license number of the CPA that the firm has authorized to sign the attest report on behalf of the accounting firm. Do members wish to discuss this topic? Do I have a motion related to client notification?
Do we need individual motions? I mean, I'd be fine making a motion across all 4 of the bullet points.
I think it would be cleaner to do, to take them one by one. If there's not a lot of discussion, it just will make it, I think, cleaner.
I mean, I have a problem overall with this, is who takes ultimate responsibility? I mean, typically the owners of a firm, the partners, they don't have a test experience. Who reviews? I don't like it at all. So I don't particularly care about taking it one by one. I'm not in favor
So
of this.
maybe just, let's continue with that. I'm supportive of each of the 4 recommended items that are on here.
Are you moving on the first one then?
To be honest, I would move to adopt the recommendation of the 4 items as presented by staff on page 6 of the memo.
All right, can I get a second of that motion, and then we can have a discussion?
I'll second that motion.
All right, so I'll open it up for discussion. Do committee members want to talk about it any further, or?
I thought each of the items, made sense in terms of I assume these are fairly rare situations where we've got, firms signing audit reports where none of their owners are, qualified with the attest experience. So the engagement letter notification in terms of as a vehicle for the client notification made sense to me. Notifying the peer review party that is the condition of the firm, I think is good, because that probably at least puts it on the right radar scope for those doing the peer review of the organization. The third bullet feels somewhat implicit to me, but I get it, that there has to be a mechanism for the owners taking responsibility for the services that that their people are going to execute, or those that they contract with under their name. So that makes total sense to me. And the 4th one I was a little bit skeptical of, as I or didn't quite understand, but I think it's become clear to me why that would be an issue that needs to be appropriate for any investigatory process that would ensue. So I didn't find any of them controversial in that regard. I agree with Michael on the need for firms undertaking this condition to take ownership. I don't know if other states have a template for how this is done. I assume not from your reaction there, and so we don't really have a best practice out there that we can look to adopt, and so that's why I thought this all made sense.
To your point about obviously, we say this often, California is unique, especially in this particular situation, because we're one of the last to have the attest experience element to our equation with the two different license types. I did note the UAA item that'll eventually be coming to members potentially this year, on how the firm may need to take on some additional responsibility related to having minimum attest experience hours over a rolling 5-year period. But for California, we are unique in this. Right now, do I think this is relatively uncommon? Yes, but I believe it's becoming more common. It's coming on our radar more often, and I think it's simply because there's more Gs than As now, in terms of where I think the As have outpaced the Gs for a long time. I do believe there's probably more G licensees than there's A licensees who are getting issued license, by far being issued almost at a 75% to 25% clip even. I think some of what we're trying to put out there is being reactive, but also being a little bit proactive and understanding this model may become something that's more common. And we want to make sure that there's additional checks and balances in place to protect consumers and to also make sure the board can do its job efficiently and effectively during the course of investigations, and not having to figure out, well, who's responsible, and should the owner be bearing certain responsibilities, because it's proved difficult in a couple of our matters to understand where they didn't perform the act, should they be considered negligent? And the answer is, yes, they should be, but can we get there? And so some of that is kind of why we're putting this forward.
So within the peer review manual, which is the AICPA's peer review manual and program that California and basically the states apply, there are checklists within those programs for the reviewed firm to prepare for the peer review, and that could be an engagement review or a systems review. There are checklists for the team captain, so the peer reviewer, to prepare for that systems review, and for the engagement reviewer to prepare for an engagement review. So, and if you look at both sides of that and what the demands are, the information that the firm has to provide and the information that the team captain or reviewer has to request, it refers to, like a list of the partners or individuals of the firm, if not a partner, who is responsible for the issuance of a report, basically. So there's a reference to responsible party. There isn't specifically, given California and our uniqueness, I suppose, the question of, well, are all these CPAs Gs, or are they As, or what are they? There's not that request from the reviewed firm standpoint, and there is not specifically that request from the peer reviewer standpoint, unless the peer reviewer is specifically asking that question. So, our question here is a committee is that too indirect? Do we assume it's happening with our peer reviewers? I mean, I don't know that. They do look at the firm's license, and all it tells is, yes, my firm is current with their license with the CBA. And that's the firm. And if I show them my license, it's going to say my license is current, but it's not going to indicate whether I'm an A or a G. So engagements are listed by responsible party, and that can mean a lot of things. So just to point that out for those of you that would like to know.
And I think the motion kind of handles that, right? Because it directs staff to at least explore possible changes to the extent that they might be required, given what you just outlined.
Correct.
Any other discussion items? Any other comments? Are there any comments from the public on this item? Hearing none, I'll call for the vote. Ms. Reed, can you handle that, please?
Mark Silverman,
Yes.
Michael Savoy,
No.
Ariel Pay,
Yes.
Carrie Ann Farrell Hines.
Yes.
Nancy Corrigan,
Yes.
and Jose Campos.
Yes.
All right, that motion carries. So I don't think that we need a motion to direct staff to discuss to come back, report back to us on the additional recommendations. Those will just come back in due time.
Correct.
All right, thank you. All right, thank you, Mr. Franzella. Agenda item number 4 is a discussion and possible action to mitigate a rulemaking relating to continuing education, and this item has been deferred to a future meeting. So at this point, I'd like to move on to public comments. Are there any comments from the public? All right, seeing none, agenda item number 6 is items that would be recommended for the next meeting's agenda. Are there any recommendations for additional items for the next meeting? All right, seeing none, this meeting is adjourned.